Let's look at the argument about purchasing firearms. The government makes two main points in their argument. Addressing the first question under Bruin, the government contends that the Second Amendment's plain text does not cover the conduct that sections 922b1 and c1 prohibit. The government argues that a limited ban on the purchase of handguns from FFLs is not an infringement on the Second Amendment rights, and in any event, 18 to 20-year-olds are not among the people protected by the right. The belief that a ban, no matter how limited, does not infringe on the right to keep and bear arms defies logic. I guess to a government that believes they have the right to censor free speech and press, infringement means something different. The idea that an 18-year-old could not only own a gun but use one to fight for our country but is not part of the people is as obscene as saying someone is not a part of the people because of the color of their skin, where they were born, or any other arbitrary attribute. We reject these points, then move to Bruin's second inquiry, whether the government met its burden to demonstrate historical analogs supporting the challenge regulations. The Fifth Circuit rejects the government's argument about the Second Amendment, then moves on to the historical analogs that the Supreme Court used as precedent in the Bruin case. Contrary to the district court's assumption, the government denies that the plain text of the Second Amendment establishes a right to purchase a firearm at any time from any source. Contrary to the government's position, they don't get to determine when, where, or under what circumstances someone can exercise a right protected by the Constitution. In other words, when the plain text of the Second Amendment protects a right to keep arms, that includes purchasing them. The government has to provide an extremely good reason to violate the due process rights of the American people, regardless of their age. Due process is defined as an established course of judicial proceedings or other governmental activities designed to safeguard the legal rights of the individual. The government keeps digging deeper. It emphasized that 922b1 only limits the sale of handguns by a particular type of seller, FFLs, to a particular class of buyer, under age 21. Of course, the words purchase, sale, or similar terms describing a transaction do not appear in the Second Amendment. But the right to keep and bear arms surely implies the right to purchase them. Again, the right to own logically includes the right to purchase, which means the question isn't whether or not there is a historical analog for these age restrictions. The threshold textual question is not whether the laws and regulations impose reasonable or historical grounded limitations, but whether the Second Amendment covers the conduct, commercial purchases, to begin with. And according to the plain text of the Second Amendment, yes, the Second Amendment covers the purchasing of firearms.